going to call this work session to order. It is 12:01. Let's go around the room and identify ourselves. We're just around the table, starting with Mr. Gates.
DJ, City Council.
Becky McPherson, Municipal Attorney.
Red Dice.
Forrest Dunbar.
Eric Croft. Christopher Constant.
Dick Trent.
Amy Kibowski.
Great, thank you. All right, so let's start. Dean, there was something you wanted to say?
Oh, Dean, yeah, do you want me?
Or Becky, either of you?
Yeah, we just discussed, we wanted to make sure that the scope of this work session is regarding the protest as opposed to the conditional use permit, which is, it concerns the same establishment, but which will be discussed in a different work session, I understand, and the reason for the distinction we want to make is that there are different rules regarding both ex parte contact and process that apply to the two different processes.
Okay. So is there someone from the administration that wants to talk about this protest? Yeah, Mr. Trainee.
Just that we should be looking at page 3 or 4, I think, because that says the cell needs protesting and needs the reason for protesting. That should be, from my perspective, what we're discussing today.
Certainly.
Thank
Great.
you,
So is there someone from the administration that could sort of lay out the issues, and then we can hear from Mr. Coffey or someone else from the applicant afterwards?
Mr. Chair,
Yeah,
I
Mr.
think
Constance.
actually Mandy might be the best one to make the initial statement of fact.
Okay. Can you do that, Mandy? Thank you. Do we have somewhere where she can? Do you want to sit right here, Mandy? Oh, I should also say there's plenty of food in the back, so if anyone wants to go get some sandwiches, please do so.
Okay, so the AR before you is a conditional protest of the renewal of the liquor license held by AK Alchemist, and it is due to the departmental reviews that are the same for any other liquor license renewal. They were not in compliance with a few of the departments, and actually the departments have representatives here, so if there's any specific questions on any of the issues, they might be better able to answer those.
Okay. Let's see. Mr. Bosky?
It would be helpful just to have on the record for somebody to present what in fact they weren't in compliance with.
Mm-hmm.
That'd be a helpful starting point.
There's a sheet.
Oh, I know, I want it on the record though.
Okay. Do you want to do that, Mandy, or is there someone else? Okay. Why don't we start with Mandy doing that, and then we'll have perhaps a response from the applicant, and then we'll go into the specifics, and hopefully the administration, the department representatives can speak to those. You want to start, Mandy?
Sure. So the review found that the clerk's office didn't receive certification from a number of the reviewing departments. At the time that the AR was submitted to the agenda, the Department of Health and Human Services had protested because there was not a valid health permit for the mobile food unit. And I was notified since then that they have renewed their health permit. And then building safety official was not, had not given certification of their inspection. There was a number of issues with building permits not being obtained. There was notices of violation that had been sent and a number of fines that had accumulated that hadn't been paid. The planning department also did not give certification. There had been a modification to the licensed premises submitted to the state of Alaska. The clerk's office received notification of that, and as part of our review process, that gets sent to the planning department for review. Their site plan does not match what we have on file, and they needed to apply for a modification, so we haven't received certification from the planning department yet. The fire department did not send certification due to unresolved conditions placed on the conditional use permit. And also noncompliance with the certificate of occupancy for the mobile food unit. And then, since this was kind of a different licensing process, there were a few other departments that were involved with the conditional use granting the license and the use for the property. So the traffic engineer was sent an inquiry from the clerk's office to see if the conditions on the conditional use had been fulfilled. We were notified that they hadn't been.
Can I stop right there? Is traffic here to be able to tell us exactly?
Yeah, they are.
Okay. Thank you.
And then also, AWU was contacted and sent notice that one of the requirements of the mobile food unit not being hooked up to any other utilities aside from electrical, they have continued to be hooked up to water. And so that was also listed on there as a reason for protest.
Okay. Mr. Trainee?
And in section 1, item 4, outstanding violations and fines, how much are we talking about? Have they been brought up to current yet?
My understanding from the health department, it was about $800, give or take. I believe those have been paid and they have renewed their health permit. The last I heard from building safety was it was about $4,000 in fines, and I've not received any notice that that's been taken care of.
I know with
As of
marijuana,
today.
we require all fines and fees to be paid.
Correct.
So, thank you, ma'am.
Mr. Croft?
So I want to proceed with this, and I know it has a lot of interesting, complex issues for important parties. I'm still stuck behind, as usual, on what you said at the beginning, which is we can't discuss the conditional use slash SLRPA on this, in this hearing, and that there are various different procedural requirements. At some time, not taken away from this time, I'd like to understand why that is and whether we can change ours to in some way conform so that we can have these two together. Because I think a lot of these are land use-y issues, and I think it'd be most efficient on in the future to be able to have these together and be able to go back and forth between the land use and the codes.
I'll say a couple quick things. One is you can certainly discuss the grounds for the protest and the ground and the concerns with the CUP that have been articulated in the existing assembly resolution are essentially the same. So you can certainly discuss the same issues. This session was noticed as a public hearing regarding the license protest and not noticed as a session discussing the conditional use permits. I think that's another factor that comes into play. And we can certainly have a bigger discussion about there are code provisions that treat the land use permit process and the license protest process differently, which we're stuck with at present. We could certainly discuss whether they merit changing.
We're not stuck with them all. We can change them
Yeah.
anytime we want. So I want to know what I need to change so that we can discuss them all together.
Certainly.
I'd like to know for the record that Mr. Weddleton has joined us. Ms. Nabowski, do you have a?
Yeah, so this is the first time I've ever had a meeting like this where I'm told I can't think of this or I can't talk about this. And frankly, in this particular situation, with this particular applicant, I don't think you can think of one without the other. I sat over the hearings when we initially did this, and it's a very complicated permit or license situation. Let me put it that way. It's a complicated situation in which initially, and I'm just going to say this so everybody's thinking about this as you're hearing people testify, initially, or discuss, when this applicant came before us, the city gave the applicant the ability to achieve the conditional use or the license, whatever, without the protest. But they said, in order to get this permit, you have to meet a condition that they could never meet because code didn't allow them to meet it. So they put them in this circle. You see what I'm saying? You can get this permit for building safety, I think it was, I can't recall off the top of my head. But you can get this permit, but you have to be able to hitch up to water, but you can't hitch up to water because you're a mobile food cart. Does that make more sense if I say it that way? So as we're having this discussion about what they couldn't do, I think it's really important for us to recognize that this was a trailblazer as far as a very unique situation that the municipality was considering for expanding our economy and revitalizing this portion of downtown. So I just want to put that on the record.
Thank you, Mr. Nabowski. Mr. Gates, did you have something you had your hand up?
I just wanted to add my perspective on how we can kind of bifurcate the conditional use process and discussing and protest of the liquor license. And to me, I think the liquor license protest because our departments, our city officials say a lot of compliance with this or that, with our codes of work. Planning is that they're not compliant with conditions that are on the conditional use permit. That's all we really need to know from them about why we should have a protest on this. And this is conditional. If they eventually, through a conditional use education, we solve that, then we can lift the protest. But all we're worried about, I think, in terms of the conditional use permit, being able to protest is, does our city officials say they're compliant with the conditional use permit or not? And just for clarification, this is downtown, so we're under old Title 21. They're still called conditional use permits, not slivers. It's an oddity I had to clarify.
Nobody calls them slurpers. Not a real thing. Slups. So at this point, I'd like to hear from, unless my colleagues have another question, I'd like to hear from the applicant or a representative.
You want me to come up there?
Yeah.
Stand in front of it?
You can sit here.
Yeah, I think standing there is just
Okay.
fine, Dan.
Thank you. Mr. Chairman, members of the Assembly, you ought to just file a protest. You need it just simply for the reason of time. Regardless of the substance, the correctness, the accuracy of any of the things that the staff is telling you, you can't, if you don't protest, then we're going to be in a different world, and the license could be issued, right, by the Assembly or by the ABC board, and then we'd have another issue here. We understand what Mandy just told you. These are their allegations of what are not correct. I've met with the city attorney and your attorney and talked to them both on the phone and met with them. Well, I didn't talk to them on the phone, obviously, but I mean, we talked. We have agreed that basically come Monday or Tuesday at the latest, I will submit documents to them, and I will deal with them and address them only. I have no contact with you folks, no ex parte, no nothing. And then those documents will substantiate our position vis-a-vis those accusations. So to have a hearing today on those accusations in advance of my material being submitted to you I would argue, would be an inappropriate way in which to proceed. Now, you might have a subsequent work session, and maybe your attorneys can tell you whether or not it would be appropriate at that time for me to testify on substance, for your staff to testify on substance, or whatever. But I think to have it come before you today without me being fully prepared to answer each and every one of these questions that they have said we have violated, and some of them are legal, and some of them are procedural, and some of them are factual, would be inappropriate. So my recommendation, the strongest recommendation, is protest on Tuesday night. Protest the license. You said enough in your protest to let it go. Do that. And save the rest of this for our 22nd public hearing on May 22nd. And I have a deadline of May 7th to file, but I'm going to get my stuff to Dean and Becky well before then, like Monday or Tuesday. And we'll see where the facts truly lie in this matter. Thank you.
I have Mr. Trainee, Mr. Bossi. Before I go to you, Mandy also would like to say something.
So I just wanted to let everybody know that there has been a protest sent to AMCO already. So for our deadline, we sent a notice saying that there was a protest of the license pending the public hearing and final action by the Assembly.
That's what I thought initially, but then I was told that it was only introduced last meeting and had not been approved last meeting. Well, apparently it was approved, because if it wasn't approved, you wouldn't have sent it.
We sent notice.
Okay, so in other words, your protest is filed, and I think, I just strongly urge that you allow this process that the lawyers have talked about to take place, Mr. Chairman, and we get to May 22nd without testimony from a raft of municipal employees today about substance of this matter. There will be a time and a place for that. Thank you.
Mr. Trainee, before I go to you, can we just quickly, I'm confused a little about this. Becky, could you speak to what Mandy just said? Did we file the protest? Well, I guess we did. If Mandy said we did, then we did.
Yeah, I'm still not confused as well, because I saw it on the agenda as for introduction last time, and it's on the agenda for public hearing tonight, so I had assumed we wouldn't file until after, but I clearly was mistaken. It's on the agenda for public hearing, you're the AR that submits your protest.
Yeah, so we did send notice on April 11th that it's being protested pending the public hearing and the final action.
It may just be, I think we as a matter of course always submit a condition of protest, right? And then we allow therefore the public hearing process to determine what the conditions of that protest are. Maybe that's where these two processes are coming together. So
Gotcha.
you could certainly on Tuesday decide to lift the protest, at which point then you would withdraw the conditional protest. Otherwise, I think the conditions that are attached to the protest you adopt on Tuesday go in as our amended conditions.
Thank you, Mr. Train.
Mr. Chairman, that's what I was getting to. It's right now, it's coming in front of us on Tuesday. We go ahead and deal with the protest, and you've already sent it on. Just make sure they received it timely and they're all happy with it. But we can pass that on Tuesday, and then, like he said, we'll deal with the other part when it comes to us.
Mr. Mossy.
Thank you, Mr. Chair. I was a little confused as to what our goal was today here because it started to set up like it was actually a hearing. And my thought is what Mr. Trady just said. I thought the focus would be asking the applicant and the staff, any of the departments, about the conditions on the protest specifically. That's what I thought we were going to. So if I may, I would just like to ask Mr. Coffey, have you had a chance to, I'm sure you looked at the conditions. Are there any conditions that you have concerns about or conditions that you think that we should add?
Well, the answer to the question, if I might, Mr. Chairman, the purpose of having the public hearing on the 22nd of May is to address each and every one of them. So what I did when I found out on, March 31st about this, pardon me, this circumstance, was start to get involved. But there were 13 conditions in the original approval in 2016, most of which have been complied with. Some of them are new things that they have inspected and issued citations for. One of them is a building permit that they didn't get for an annex. I was sort of curious about that. And I don't want to get into the substance, but the point is I'm prepared, and my client has put together a whole package which he is delivering to me on Sunday, which I am then going to file with the city attorneys. And it will address each and every one of the conditions in the original one and the things that are stated in the 2018 resolution.
Okay, and the reason I was a little concerned was because I didn't also realize that we'd already filed a conditional protest. So I guess it gives us a little time, but as an assembly member, especially with this being probably the most complicated one we deal with, you've been through the process with me before. I don't know how on the floor I'm supposed to read what you say, and if I agree or disagree, draft an amendment to this particular AR. I mean, do you see what I'm saying? I think it's challenging. So, in your view, you've done this a lot. Since you have a conditional protest filed, do you think if, for some reason, there's substance before us on Tuesday night, that we have to take action on Tuesday night?
Well, if your procedures require you to take a formal vote to submit the protest, and it was submitted only for purposes of advising the ABC board, which I'm not familiar with that, but if you should absolutely pass the protest. There's just too much here to not pass that protest. But then we should be able to take whatever time is necessary, as we did in the first instance, to get through all of these issues. And May 22nd is the current deadline. My understanding, and you should confirm with your own counsel, but my understanding is that deadline can be extended and your protest stands. So the risks of something unintended at the assembly level would not occur. You've protected yourself everywhere, and we can determine whether or not these allegations are correct, whether they are substantial, whether they are significant enough to deny an extension or a renewal of the condition.
Thank you.
So-
Can I ask legal a question?
So Dean was in the queue, actually. I don't know if that's...
Well, I just want exactly what he's saying,
Okay.
just to follow up on my line of questioning. Dean.
Someone
or-
take Dan a chair over there. He's making me wildly uncomfortable.
Okay.
My concern, and maybe it's not a valid one, but my concern is, as I'm looking at this, because I know how complicated this one is if there's something substantial in our conditions, we passed this on Tuesday night with a whole list of conditions. What if more information comes to us, we have a few days to analyze it, and we want to go back and amend those conditions on that license? We haven't, how do we word it in such a way that the ABC board doesn't just adopt our condition specific and just adopts, what if we change it, I guess is what I'm trying to say.
Well, I guess Manny doesn't, you want to comment first, Wendy? Yeah.
Sure. So typically how these have been done, we can just word it as the boilerplate protest pending certification from the lacking departments. So I think that's something to keep in mind is I know that the conditional use permit was very tied into the licensing process, but this is specifically for the renewal of the liquor license. And the process that we have for reviewing the renewal of the liquor license is if they are in compliance with the requirements of code. So I know that there were a lot of conditions on the use permit that are mentioned in here, and it's hard to separate them because of that, but a lot of it can just be taken care of by saying we have to wait until we get certification from these departments and maybe not specify so much.
Okay. Yeah, that was one of my biggest concerns. Thank you.
Mr. Gates and Mr. Constant.
While we were discussing, I looked up our April 10th agenda, and this item's just for introduction. And at 9 of 5, that shows the action on our online agenda, and we're taking this only to set it for public hearing Tuesday, 24th. So we, as Mr. Coffey said, we take a vote on the protest, so we keep the tree standards and so just as a point of information, we do need to take a vote on that Tuesday. And then I think Mr. Invest keeps asking me how do we add conditions to the license, and I think you similar to what we did for some license stores not long ago. I'm thinking about that actually.
Well, and I don't mean necessarily add, I might mean take away. I mean, but my point is, I wanted to know how specific the board would take our conditions, because if more information is coming to us and we're not going to get it till Tuesday, I know how complicated this particular case is. I think personally, I don't see what the big deal is, saying they have to meet all of our conditions, they have to get all their checkoffs for their permits and all that kind of stuff, and until they do so, they can't be up and running. So I think what I'm hearing from you guys though is if we word it in such a way, we actually can make them compliant as long as they're compliant with the checkoffs by all the departments.
Yeah, I think that's the case. I mean, I think what this is, because all we're saying is that they have to comply with the conditions that have been placed on the property by various departments' permits, and then as soon as we determine they have complied, I think the question that will come up in May 22nd is, have they complied or are they out of compliance, and what do they need to do to become in compliance? So to the extent we determine they are now in compliance or figured out a way to get them in compliance, then I think this is lifted. And then that protest goes away.
Okay, so I've got Mr. Constant, Mr. Croft, and then Mr. Coffey.
Thanks. A couple of things. First, Mr. Coffey, is he currently operating?
He's in business, but because of the condition of the weather, he's serving, he serves on the outside deck, and he has not been.
So is he, to the department, still able to serve alcohol at this time? Well, you folks haven't taken any action that prohibits it currently, but I think, though, that he received a letter in April that says your license is expired because there's no conditional use. And so the reason I say this is because I believe, and I may be wrong, I'm no attorney, and I'm certainly not in the alcohol business, but he isn't allowed to sell alcohol at this time because there's been a finding that he's out of compliance. And so in some ways, time is of the essence from a business perspective. I don't think that we're going to see a long, drawn-out process in the next several weeks because it's in his interest to get this done, and it's obviously in ours to figure this out. I want to point out, back to the point of the conditional use versus the license, that we're dealing with this question so we can deal with the question of the conditional use, which is this conditional use is extraordinarily rare because I haven't heard of another example of a limited temporary conditional use being issued or existing at this time in the city. And so it is very confusing. There are two processes, but I do believe we need to pass this. And I don't know if your question is valid. Should we have an amended version of this that doesn't talk about the conditions of protest so that it's clean over to AMCO and that we deal with it in-house rather than communicate that forward? I don't know the answer to that question. It's one that we should ponder.
Thank you. Mr. Croft, and then Mr. Coffey, and Mr. Trainee.
Yeah, responding to both Ms. Dombrowski and Mr. Constant, It does seem to me that it'd be cleaner. I think, Amy, you have a very good point that you say, I don't know whether we're going to agree that they need to meet all 5 of these, add something, say not 2 of them, but what something else. And so this both may be too broad and not broad enough, right? I mean, so really, don't we mean, and can we say, we protest it generally, and we're going to have a big hearing in the whole process and decide it's 1 and 3 and something we haven't talked about yet. And so I feel, because I've known him a long time, Mr. Coffey wants to comment on that, so that would be, I guess my suggestion is we generally protest. And then do we have the ability to say later, we told you, ABC boards, not ABC board anymore, that MCO, that we generally protested. Now we're saying it's protest with these 2 conditions.
Well, I think so you're suggesting that in lieu of a conditional protest, we file an actual protest that says we protest renewal altogether. This establishment is for these grounds because the establishment and that we don't want it to be renewed, or because this is a conditional protest that says you can renew it, but these things have to be resolved first, right?
Well, right, and it gives the power when they are. It automatically she's directed to do certain things once this checklist of 5 is met, and that may not be the right checklist.
But I think you're gonna run into the standard is the arbitrary, like reasonable or not arbitrary that we have to if your protest is just we don't like it, we want it to not be renewed until we say so, or some more general version of that I think is going to be challenging to like for AMCO to review. If you want to say you could certainly make this a more general condition that says until the applicant resolves all outstanding non-compliance issues with the municipality has received approval for additional extension of the CUP that acknowledges that all these issues have been resolved, or something more general. You could compress these into a more general condition, but I think it's important to not just have the condition be we're protesting, we're not giving any specifics on how the protest can be resolved, or...
Boy, I just couldn't disagree more than that. I think there's adequate grounds to protest. And it's confusing conditions and grounds. You can say, for all these reasons we protest, and it's not arbitrary.
Oh,
but
certainly.
that doesn't
yes, then you can say that. You can say that it's not a conditional protest. These are the reasons we protest. You should not renew the license. You could certainly do that. Say, don't renew the license. There's all these issues. That is our protest.
And then the second, real quickly, the heck was the second one? So how do we can we then, after a general protest, say we have amended our general protest and now we mean a protest with the conditions, and
protest.
It's now these things?
That's a good question. I'm not sure I know the answer to that. Amanda, do you know the answer to that? If we've already submitted a general protest, can we then subsequently rescind and submit a conditional protest? I think we've then passed the deadline. Yeah.
I don't think we can do that. ANCO and the liquor license protest from the local governing body is basically saying we don't want them to have a liquor license anymore. Yeah. So if we just say a general protest, saying we don't want this business to have a liquor license, period. If it's a conditional protest, it says we don't want them to renew now because they haven't paid their taxes, they haven't done these things. And if they do, we don't have otherwise in the protest. What we've listed here in this resolution, paragraphs 1 and 2, they really refer to conditional use permit and the conditional use permit requirements, having all the certifications in place, having the site plan review, traffic moving plan, that's right, and all of that. So if they can meet all of that, May 22nd, they can simply decide to renew the conditional use permit, extend the date, or remove the expiration date on the conditional use permit. Then this part in this resolution would be not that we could check off from the ones into the year. So that's how I see it. But if we don't do conditional protest, just with outright general protest, then this body is saying we don't want them to have a liquor license at all.
Well,
Okay,
so I'm going to...
Yeah, just the second one, which I forgot because I'm getting old, but it was Mr. Constant's point. What is the effect on ongoing operations when we say we protest? It hasn't gotten to the ABC or the AMCO yet, but we are saying we either conditionally or generally protest. Does that mean during the pendency of that they can't serve, or not until that is resolved? And those are the two questions.
Aaron, we have an expert here.
I know, and I'm trying to get the questions out so that they can answer.
Are you
We have more
referring to
than
Mr.
one.
Coffey?
I'm referring to Mr. Coffey.
Well, he's been in the queue patiently waiting, so let's, Mr. Coffey, let's hear from you.
The ABC board does not enforce in any way, shape, or form your conditions, your, whatever you require of a licensee. That's, you do it through the conditional use process. Your enforcement lies with you. However, if you put conditions like you put in here, or in general anywhere else, they will not deny the protest unless it's determined to be arbitrary, capricious, and unreasonable. So, and we, as the applicant's attorney, we're not going to go over there and ask them that. We're trying to resolve the issue, not create some hearing at the administrative level and on and on and on, I mean at the ABC board level. So that's why I say, I don't know that you have to go through anything more. You have, I would formally file it if the informal thing wasn't done. I'm not sure about that. But once that's on file, there will not be any, the license will not be renewed, and there will not be any liquor license sales from that business, which will be very costly to that business. And so we are anxious to get it resolved as quickly as we can.
Ms. Honest?
So Judd Smith is here, and he can correct me if I'm wrong, but my understanding is a lot of times with the protests that we submit to AMCO, if they're pending certification from departments, the ABC board does a similar process that the assembly does, where they delegate the authority to the director to issue the license once their issues are resolved. So my understanding is they're issued temporary licenses to operate until that period. And Judd can correct me if that's not right, but they wouldn't be shut down.
Mr. Constant?
Yeah, it still doesn't resolve the question of the lack of conditional use at this time. And so,
But if you could
Yeah,
rephrase,
please.
when you extended the conditional use permit, the AR that extended that did not terminate their ability to operate. It extended the terms of that conditional use permit. So they currently have a valid conditional use permit that is in place until May 31st and pending this public hearing on the next October.
can you answer what action we took that extended the conditional use?
You adopted an AR that extended the conditional use permit for 60 days and
Okay.
also set a public hearing, provided notice to the applicant that you were seeking a public hearing on their progress.
Thank you.
So Mr. Bassi, before I get to you, is there anyone, I just want, we got 25 minutes. We've heard from Becky, and she's an excellent representative of the administration. But is there anyone else from the administration that needs to speak or get the view of their department on the record? Are we good? Okay. Mr. Bassi?
Thank you, Mr. Chair. I think one of the more complicated things I've dealt with on the assembly, surprisingly, has been either land use or liquor license issues. But I think we're making this one more complicated than it needs to be. When I'm looking at this right here, ultimately what we want to make sure is we want a conditional protest to the ABC board, making sure when they issue that license again, that they've met all of our conditions, all of our requirements here at the city. And so what I was trying to focus on was this. I was not saying general protests. I don't think we should include liquor license. I have not heard that they're a bad operator down there. But what I'm saying is I want to make sure that our language was good. And as I look at them, none of these conditions shock me. But I just want to make sure, because Mr. Coffey says he's going to have all this information for us. I don't know what that means. I don't know how complicated it's going to be until I see it. So I guess where I was focusing in on was the conditions right here on page 3 of 4. And I think as I look at them, I mean, essentially what it's saying is like every other operator, you have to follow the law, you have to pay your fines, you have to, well, I may not be in there anymore, but you have to be compliant with the health inspector and the fire inspector and all those things. So this is really actually pretty standard. I just wanted to know that. And the other thing I would ask, because it sounds like we're going to have a lot more discussion about this particular applicant, it would be really helpful if the clerk's office could distribute the final package from our hearings and everything we did on this, so people can read the background history on it. It would be really important to do that. So that would be helpful, Mr. Chair.
Thank you, Mr. Bassi. I don't know, there was kind of a question in there, right, for Mr. Coffey, I think, about the appropriateness of these particular these particular conditions, do you think there should be any changes to these before we get to the hearing on Tuesday?
No,
Okay.
I mean, you're safe at the ABC board. I mean, the process is in place that will work just fine with this.
Thank you. Mr. Trainee?
Just one thing I want to correct earlier, you said she represents the administration. No, she doesn't. She is in fact our attorney. He is our good attorney, but he does not represent us in court, nor does he represent from the AMCO board. She does. So when we need to rely on her legal opinion in this effort, because he doesn't go to court, she does. It's important to remind the assembly what her role is. You're not the administration. You represent us.
Well, fair enough. Then we've had no one from the administration speak to us. Mr. Constant?
Yeah, so last night, the Downtown Community Council's Alcohol and other related measures committee met and had a discussion about this. And their position was they've heard no complaints, they have no complaints, and they're supportive of the business if the business meets the conditions the assembly sets. So it doesn't help us much, but they aren't in opposition to the renewal of the license or conditional use, but they want to make sure that we're okay with it, so.
Okay. Is there anyone else who, no, for the record, Mr. Steele has joined us. Is there anyone else that wishes to be heard, or any other concluding remarks, and we could end this work session a little bit early? It sounds like the next major action is just a vote on Tuesday. Is it the case that the attorneys and Mr. Coffey are going to be working in the interim, discussing this further? Is that the plan?
Yes, sir.
Okay.
Yeah, the plan is for us to. We are in a little bit of procedural no man's land here. I think we're all feeling it a little bit because this is, to our knowledge, the only time this has ever happened. So we're dealing with a creature that is sort of entirely of assembly creation. It doesn't specifically fit into any specific part of the code. So we've been consulting about what the appropriate process is, what the appropriate rules are for the hearing on this, and we're going to continue working on that, and we'll have the material the applicant submits as well.
Thank you, Mr. Thompson.
Yeah, that's, now that we're on to the philosophical a little bit, the unusual, I love planning, and planners keep the book square and everything in order and tidy. But this process defies all categorization. It is not a brick and mortar building. It is not a food truck. We have not authorized a liquor license for a food truck, although some areas of the operation are regulated under food truck rules, and some, as it sits, are regulated under brick and mortar rules. And so the planners are rightly hesitant to see something of this nature move forward. And the business owner, obviously, and members of the community who see a positive influence in that area are interested in seeing it proceed. But we have to sort through kind of phase 2 of that first round of the problem. Going back to what Ms. Nabosky mentioned, this conundrum of there are conditions that are impossible to meet. They're circular in nature. You must do this and you can't do this, therefore you will fail. And so that is really going to be part of the important discussion we have at the next work session related to the conditions. But we have a fundamental paradigm problem here that we're being asked to resolve that goes right to the no man's land, not just the procedural no man's land, but the categorical no man's land as well. And so it's a very interesting thing.
Mr. Nabosky.
Thank you, Mr. Chair. Going on to what Mr. Constant just said, if my recollection is correct, the Assembly basically did this over the protest of the Planning Department. They really didn't want us to do this. We did it anyway, because we saw the economic value to revitalize this portion of downtown, and the plan before us was a reasonable one. So I think that's important to recognize that we don't always necessarily disagree, but since we're the lawmakers, we get to sometimes do what we want to do and what's in the best interest of the community. But the second part of our discussion, when we start looking at this a little further, in my mind, what I'm looking at is what conditions did we put on them before, and did they work? Did we have a problem with those conditions? Should we reduce them, or should we increase them in some area because of concerns that were raised? So because this is the trailblazer for this type of operation, I think those are the things we have to look at. And this is the reason we didn't go back we didn't go hard and rewrite the whole code to allow liquor service from food trucks, because we didn't want to have a mess on our hands. We wanted to inch our ways into this type of potential expansion of allowing liquor licenses in different types of establishments. So I think all of those discussions, hopefully members can think about that when we're discussing it, because I think they're all relative to the topic, and I think it explains why we didn't go trailblazing and write all kinds of new code just to allow this one to operate, because we didn't know how it was going to work out.
Thank you, Ms. Nabasi. So it sounds like we have a path forward. We're going to take a vote on Tuesday after the attorneys negotiate more. We'll clearly have another work session, I think, between then and the 22nd. So, Mr.
Can I ask
Coffey?
a procedural question, would, and maybe for your counsel? If we had another work session before the May 22nd hearing, would we be able to communicate in this forum?
I think so, because this is a publicly noticed forum in which all members of the Assembly are present. My concern is only with, I think the code is only concerned with ex parte individual contact between you, or if you're anyone concerned about your client's business with respect to this public hearing.
Yeah, okay, I just wanted to confirm that we wouldn't come in here and find we ran into an ex parte communication problem.
Thank you, Mr.
Although
Coffey.
But I would love to have it after we've submitted our material.
Thank you. I'm going to give Mandy the last word.
I just have a clarifying question. So the public hearing for the renewal of the liquor license, we have it as April 24th. My understanding is that it's the public hearing for the conditional use permit that's in May.
Yep, that's true.
Okay.
All right. With that, I'm going to close this work session.